Okay, hi everyone. It's Grant Abbott speaking. Welcome to this session. We've got quite a bit to go. Obviously, it's getting towards year end, so everyone is just frantically busy, and no doubt everyone's going to poke their head up next week to look at all their various tax strategies, etc. I've got a session at 12:30 today where I'm going to go through my top 7 tax strategies for year end using superannuation. So that'll be out and about if you're available for that. If not, you'll find that's recorded and sitting up on the Lightyear Docs site, as this one is as well. So what I wanted to do today, and look, many of you have been, you know your trust really well. You trust the law very well, and your tax law, as many of us do, particularly those who have studied it as tax professionals, as both Tony and I have done, and through our Masters of Law. Obviously, trusts were a very important feature. But what I wanted to do is just sort of give you a heads up of where we are in terms of the Lightyear Docs rollout. I wanted to talk today about our discretionary trust just briefly, which is a pretty stock standard. I just want to talk about a couple of little instances in there, particularly around Bamford and the meaning of income. The other one I wanted to then have a look at is the leading member, and I'll focus a little bit more on that and that leading member suite. We'll have a look at the Family Protection Trust, which has just been put up on the site today, and I'll explain the difference between that and discretionary versus the leading member. Really, at the end of the day, there's not a huge amount of difference between the Family Protection Trust and the leading member trust. It's just a lot nicer way of putting things, I suppose. It's a bit of a marketing veneer, but there are a couple of little differences. I'm then going to discuss our testamentary trusts, which are built into our wills, why we're a little bit different, particularly around the totality of the testamentary trust. Quite often you'll see where a lawyer will prepare testamentary trust, they'll put the whole trustee into the will, which it's okay, but the problem about it is that's a lot of stuff for your clients to actually get on top of and implement, and there's no necessity to insert that in there. Of course, there's a great justification for charging, $6, $7, it's $10,000 for a will with testamentary trust because it's padded out. But at the end of the day, it's the core terms and conditions that are embedded in there for the executor actually to build that trust. And you'll see in our system, there's you can virtually build probably about 10, 15, 20 testamentary trusts. So you can imagine putting all of those in one package, including perhaps a special disability trust, so on and so forth, that they just blow your clients away, and they would never get around to signing it. Neither would I, because I just wouldn't know what was in there. So we've kept it fairly simple. I'm then going to look at SMSF Death Benefits Trust, which essentially can be created through the estate, particularly by way of a super proceeds trust. So we're just calling it SMSF Death Benefits Trust. But there's another provision in Section 102AG of the Income Tax Assessment Act 1936, and primarily we're looking there for dependent children. Whereby a SMSF Death Benefits Trust can be established by the trustee of the fund, provided that child, and child was any child for that matter, and you can create SMSF Death Benefits Trust. So we're not looking at just minors, we're also looking at adults, disabled children, all that, and setting that up straight away from the self-managed super fund on the death of a member. Importantly, the difference between that and the testamentary trust is that the capital on vesting the trust has to go back to the beneficiaries or whoever the child was. So we'll have a look at that, because I think that's probably one of our better solutions, particularly when it comes around to family provisions claims. And of course, I could go on a lot more. I could go to unit trusts, I could do superannuation funds, which are trusts, but there's just not enough time. So I want to give you a big, broad overview of that. I'm going to create a family protection trust for you, and then that will round us out for the day. So trusts have been around for essentially thousands of years, well, 1,000 years now. I think the first one was in 1028 or thereabouts. There's a huge body of case and statute law. It evolved in England. Effectively, there was the common law, which is just the law of the land. The problem about it particularly came to fruition in the Crusades, which was, I forget, that was in the 14th century or 15th century, it's actually in the 12th century, I think, where the crusading knights would go over seas and fight for the kingdom of England. And then what happened there is essentially they would transfer the title in their land to a friend or a colleague or whatever. And then when they came, well, obviously on the assumption they weren't going to come back. When they came back, they found that the underlying person they transferred it to, they were expecting to transfer back, but obviously they were doing quite well out of it and didn't want to do it. So they ended up going to the Court of Chancery, and at that stage applied for that title back, which couldn't be done because it was under common law. So it was virtually a contract. So what happened there is the law of equity was born, and out of equity was trust, so that the new landholder, the one it was transferred to, was deemed to hold the property in trust for the night while they were overseas. So that's where it sort of came around. It was also a very big one in relation to death duties. And I know Henry VIII had a big issue around that, but the first tax use was basically in the 15th century. And in those days, a landowner would tax a landholder on their death. So it was the first instance of death duties. And then what transpired from there is obviously the trust got around it because there was no death of the trust, even though the underlying the landholder or the landowner, so the landholder remained on foot because it was within a trust. Henry VIII got around all of that. In fact, set up a criminal court to prevent all that sort of stuff happening because he realised there was a huge drag on his revenue, and that went for a couple of centuries, all that argy-bargy around it. Now, for Australia, obviously, trusts have been around for quite some period of time, and we've adopted all the major equitable legal principles from English trust law. And I certainly know from my perspective that when I was at university and doing my Master's Law, we spent a lot of time on that equity side of the equation. For accountants, obviously, they're bread and butter. You guys know how to use them for tax minimisation purposes. I think there's over 900,000 family trusts in Australia. And you probably remember the last election that Labor Party was going to deem all distributions taxed at 30% in family trusts, which would have destroyed them. In fact, over in the UK, they have destroyed family trusts by providing penalty taxes on those family trusts. So whether they stand the test of time, look, we're not quite sure. The good thing about the Labor Party proposal was that effectively testamentary trusts and also farm trusts were to be excluded. So we've still got that body of law. Honestly, to be brutally honest, out of this COVID-19, there's going to be not small budget holes, there's going to be huge budget holes that will obviously need to be repaired over a period of time. So we're not sure what's coming down the track. The big ones, when we have a look at tax, is obviously super's the big ginormous hole there for the government, and then obviously there's the issue of trust and income splitting, which to me it's fair enough anyway. Now, trusts are all around us. Sounds like lovers all around us, almost the same thing, but trusts are all around us when you have a look from super funds, managed funds. The original managed funds were set up as a unit trust. The reason they did that is that if you use companies in Australia, would have been taxed on profits in the company, and then when dividends were received, they were taxed as well. So it was double taxation. Hence why unit trust we use it. There was only taxation in the hands of the unit holders. That's since obviously changed with imputation credits and refundable imputation credits, which has seen a lot more of the listed companies now take vogue rather than obviously managed funds, which are based on a unit trust structure. We've got testamentary trusts, special disability trusts, child maintenance trusts. You know, the list goes on and on. There's a special place and special use for each and every one. And it depends. For example, a special disability trust is extremely useful in some circumstances under Social Security. We did one recently with good friend of ours, a good advisor, Eric Sears, was doing that for clients, and did a fantastic job on that. Child maintenance trust, I've done that in the past just for myself. That I settled property into a trust under a family court order, and then when distributions went down to my children to pay for their education, so on, lifestyle, effectively it was just taxed at ordinary marginal tax rates. So what we find is a lot of these little trusts with a naming right really relate to specific circumstances. They're all based on, essentially, a lot of them discretionary trusts, but they are for special use. Therefore, we give them special name, like the SMSF Death Benefits Trust. So the key features of trust, which we'll have a look at, but essentially a settlor settles a trust with a small sum of money or property into the hands of the trustee for the benefit of the trust beneficiaries. The tax office came out a little while ago because superannuation funds are trust by nature. And it was, and I think it's still somewhere on the tax office website, that when you do have a superannuation fund, that you do need to settle it with a small sum of money for it to be effective, although I've yet to really see that play out. I talked about the Child Maintenance Trust, and for those who are interested, you can have a look at Section 102 AGA around that one. And as I said, you can settle property inside of these trusts, and it could be intellectual capital or intellectual property or property per se, and then income from that trust, when it flows down to children, is exempt from, it's one of the accepted, they're accepted persons under Division 6AA of the Income Tax Assessment Act, so they're not subject to those penalty taxes. So again, it has to be pursuant to a family law order. We will be bringing that out a little bit later on light year docs, probably towards the end of the year when we start getting more around the family law side of things, and we'll be bringing those child maintenance trusts. Again, it's going to be a discretionary trust with a few tweaks around it. One of the key issues around it is that when you do settle the property into the trust, that property has to be vested in the beneficiaries when that trust is wound up. So that's one of the key ingredients there, which is a bit different from a testamentary trust. But the SMSF Death Benefits Trust that comes out of which is settled by the trustee of the SMSF, that has a similar sort of nature. But I'll look at that a little bit later on. These are the resident minors tax rates. So you can see here all the different years, and I can't say that it's going to change at all for the 21-22. So the 2021 year is there. So up to 416, there's no tax. 417 to 1307, 66%, and over 1307 is 45% plus NDIS and all that. So from that perspective, it's certainly not the best to obviously income split with minors, and that was the reason it was put in there. We tend now to use bucket companies instead of that, but we'll see now with those bucket companies that effectively, although the legislation hasn't come out, we are looking at a commissioner talking about the instances of those bucket companies lending money back to the family trust will effectively be brought under Division 7A. So we've been watching that very closely at Light Year Docs to make relevant amendments to Div 7A loans there. Okay, so what I want to do from there is let's go out to our next stage here. So reasons to use a trust, obviously taxation and income splitting. So we've already talked about that one as well, particularly if you've got adult children. One concern there is, of course, if an adult child has a UPE that's sitting on the accounts of the trust, just be careful around that one if they ever seek to recover that. One of the major issues, in fact, just found out my daughter, her mother's been putting her in as obviously a distribution beneficiary because she's been to university. So it'll be interesting to see how that one plays out. So Just be careful of that, maybe gifted back or potentially transferred over into a family protection trust, which may be a better methodology for doing that. Bankruptcy protection, again, it goes without saying. Obviously, there's clawback that can arise for that, so we've just got to be careful about that. Litigation protection, family law protection as well. There's a couple of high court cases on that. As if the individual doesn't control the trust, then effectively it'll just be the income that comes out is going to be part of the relevant income to be taken in for a family law court order, rather than having the whole trust as matrimonial property. Family provisions protection, obviously under most succession acts and family provisions claims, we have a scenario there that any assets that are sitting in the estate, an eligible person, depending on the relevant section, for example, Part 3A of the Succession Act in New South Wales, have opportunity, I think it's Part 3 or Part 6A, one of the two, has the opportunity of, if they feel as though they were left out of a will or didn't get what they were entitled to, they can make a family provisions claim against the estate or against that executor. So again, if monies are sitting in the trust, again, that the family provisions actions don't override or don't eke into the trust, although there are a couple of exceptions in New South Wales when we have a look at notional estates. So just got to be careful there. But if it's already set up in a trust, then you're okay. The bloodline limitations, so we can overview, we can put a bit of an overlay on our trust, and you'll see when we come around to leading member and family protection that essentially they're both built for lineage and also bloodline, so that's pretty important. Protection, looking after disabled or special needs children, as I said, Eric, one of our better advisors, has been doing that quite considerably. And one of the other ones that's just popped up, and we're doing a session on this next Tuesday with Michael. And when we have a look at that, I think it's at 12:30. I'm not sure, but we're looking at the cash flow bonus or the cash flow boost that has flowed into many businesses. If it's in a trust, essentially it's neither assessable nor is it exempt income. So if that's distributed down to beneficiaries, what's the taxation consequences of it? And more importantly, how do you cover that in trust distribution minutes, which we will be looking at over the time. And so we've got here, someone's going, can you not distribute profits, have the trustee pay tax on the income? Well, essentially, if you distribute any profits, it actually comes down to whatever the income is, you need to have a look at the trustee. And I think it's probably incumbent upon all of us, particularly with this cash flow bonus or capital allowances, etc., that we need to go and have a look at what the definition of income is inside our trust deed. Importantly, from that perspective, if you've just got net income that is to be distributed, you've got to be very careful, because net income doesn't even include franking credits, nor include this cash flow bonus. So we need to be really careful that those distributions are made that are appropriate. If there is that extra amount, that accounting income amount over and above the taxable amount, that when it goes into the client, that it can actually be distributed by the trustee, not held or retained into the trust. If there is no distribution made, distributions need to be made by the 30th of June. Otherwise, the monies are left inside the trust, which may be the danger that if we distribute the profits, yes, the trustee could pay the tax, but essentially it has to be assessed to the individual. If we don't have those distributions by the 30th of June, then the trust pays tax at the top marginal rate. So we've got to be extremely careful around how we facilitate that process. But we'll look at that a little bit more when we come on Tuesday again. Now, traditional discretionary trustee, you've obviously got a wide range of discretion there. Our deed, you can see there, can distribute franked dividends, tax, overseas tax income, capital gains. You can also distribute just ordinary income, income that is accounting income as well, and that will come pretty important from the cash flow bonus, as we talked about as well. So that we want to have that flexibility. One of the good things about that is the Commissioner came out with a ruling in 2012, post-Banford in 2010, because obviously a lot of deeds were being upgraded at that time to cover for the distribution of income as per Banford, because a lot of the older deeds just didn't have that ability to distribute different lines of income and capital gains. That effectively upgrading or upgrading from a current discretionary trust to a light year docs a deed doesn't amount to a resettlement. If you split the trust to different beneficiaries within the trust, which seems to be increasingly popular, then that will create obviously a resettlement, or if you set up a sub-trust. So we've just got to be careful about that one. But if you're just adding beneficiaries, extending the vesting date, provided fits within the rule, the rule against perpetuities, then that in itself won't change or won't create a resettlement. And the Commission's got quite a long list of, has got an extremely long list of the law around that, if you need to have a look at that. As I said, vesting rules there are 80 years generally. Jurisdiction unless the jurisdiction chosen in South Australia where the rule against perpetuities doesn't apply. Bigger wide range of succession appointors and beneficiaries. Now, are you there, Tony? He might just be out for a quick coffee. I was going to get in to come in and have a bit of a chat on what his experience with trusts have been, being obviously our head lawyer in the firm. So he might have been on the phone there. Okay, so let's go. We've got our straight discretionary trust, which is perfect for the matter. Now, our leading member is very much the same as the discretionary trust deed. It's got the same sort of legal bones, and obviously you can distribute to beneficiaries, and I want to talk about that in a second, and why it's different from a discretionary trust deed, because you need to make a choice of which one is the most appropriate for your clients. So what we've got there is effectively the leading member is the person who's the appointor. So we have a leading member appointor, but we then need to start to put in a wide range of, not a wide range, but a lineage of succession, so that we've got the first leading member appointor, the second, the third, the fourth. Now, at the end of the day, the appointor generally, as I said before, is the person who controls that trust. So for family law, for a lot of other purposes, we don't want to necessarily be caught as the appointor if the stuff starts to hit the fan. So in that instance, if someone dies, if the leading member appointor dies, has dementia or becomes mentally incapacitated, resigns, retires, somebody just doesn't want to hold that role anymore, that at that point in time, they're no longer the leading member appointor, and automatically within the deed, the next leading member appointor is appointed. So there's no appointment requirements, there's no meetings, it just happens as of right. Now, at that point in time, you need, if you're looking at control, because again, we're trying to build a moat around our clients' affairs to give it security, safety, and certainty. And as a consequence of that, what we want to do is make sure you use the leading member corporate trustee. In that one, obviously you've got a trustee, but at any point in time, it doesn't matter who the trustees are, the leading member appointor, if they're part of the directors, they automatically go as chair, and they have complete veto power over any decision making. So more often than not, it's just as easy to have a single director corporate trustee with the leading member appointor as a single director. Now, the big issue, one of the major elements of having this leading member corporate trustee is essentially on death of the leading member appointor. If the shares are in their name or held jointly, etc., the problem about that is those shares will devolve down into the estate and be subject to potentially a family provisions claim, which could end up locking up that family trust. If the executor is weak and gets attacked by a very strong estate planning litigation lawyer, they'll be too frightened of doing anything around those shares. Ostensibly, they could provide the shares to anyone who would then be able to come in and take control of that trustee, particularly where there's the case that there is no secondary or third appointer, which I find is the case with most discretionary trusts. We've got one appointer, but there is no succession chain in there. So what we want to do is, inside our leading member corporate trustee, what happens on death is that or resignation or any of those instances when the leading member or appointer just simply backs out of it, for example, they're bankrupt, etc., then what will happen is their shares are cancelled and immediately new shares are issued to the next leading member. Now, if there is no leading member, we haven't done our succession, then it essentially goes back to the trustee to determine who the next leading member is, which again, that's pretty weak. So if you follow my philosophy coming down the track, particularly when you're looking at estate planning, EPOAs, leading members, we need to have that chain inside the family. And so that's the big discussion we have with our clients, is who is going to be in that succession chain. And they need to be someone down that whole line, that they've got to be smart, they've got to be ability to withstand any attack. More importantly, they've got to have some of the financial nous and work closely with you as advisors. It doesn't make sense, for example, to put a child in rehab there. So what I'll do is, let's have a look. Tony, are you there? And someone to talk about Marcellus case?
Yeah, I'm here.
Do you want to go in? Because I know there's a lot of stuff down in Victoria, where you are from, around the Marcellus case. Do you want to just go through that? Yeah. And let me just finish this leading member stuff, and we'll go to that. So again, the other difference about the leading member deed, and I know Tim's online, and thanks for coming online there, Tim, that effectively his clients love that leading member concept, because not only have we got someone in control, but again, beneficiaries are limited to the bloodline and lineage. And in fact, when you have a look at, you go through the interview process to set it up, the spouse of the leading member is not a beneficiary automatically. You have to put them in. If you exclude them, they're out of the beneficiary, which also is important, because if you retire as a leading member appointer and it goes down to the next one, then effectively you're having quite an impact on the chain and the lineage. But anyway, do you want to have a quick chat about Marcellus case? Because obviously that's raising quite a lot of issues.
Good morning to all. With this Marcellus case, it's a very significant case all round, I guess, which changes the landscape basically of SMSFs and trusts also. So what I'll do is I'll give you, without going with all the legal jargon in it, basically what I'll do it in layman's terms so everybody can understand it. What I'll do first is give you a bit of a summary of the facts. Then I'll lead you in basically of the practical implications for trustees, and then just finally a few points, some lessons to be learned from superannuation members and trustees. So, in short, what happened in this case is that the deceased was a member and trustee of her SMSF with her daughter. And after the deceased's death, the daughter appointed her husband as joint trustee and promptly paid the entire death benefit of her mother to herself. The deceased's second husband was unhappy with that decision, so yet there was no binding death nomination in place. So the SMSF's trustee was free to exercise its discretion in deciding to whom to pay that death benefit. This was because the trust deed gave the trustees absolute and unfettered discretion as to who would receive the death benefit. It did not require the trustees to give reasons for any decision they made in determining how the death benefit should be paid. It was on this basis then that the trustees determined to pay the whole death benefit to the deceased daughter. However, the Victorian Supreme Court ordered, this was at first instance, that the trustees' decision should be set aside and the trustees should be removed from office. Now, the daughter was unhappy, so she appealed it to the Victorian Court of Appeal. The Victorian Court of Appeal did not change its decision and found that, one, the trustees did not have a proper understanding of their duties under the superannuation trust deed, and two, all SMSF's trustees must exercise good faith when exercising discretions, and that this obligation is unaffected by the fact that the trustee may be an eligible beneficiary under the superannuation trust deed. And in this case, the trustee did not meet its obligations to exercise discretions in good faith. So the Court of Appeal held that even though it may have been the intention of the deceased to distribute her death benefit in a way that the trustees had, this is not relevant where the trustees had failed to give real and genuine consideration to all the relevant matters in making their decision. So from all this, what I'm leading into now is the practical implication for trustees as a result of this decision. And this case has significant practical implications for SMSF's trustees. And the trustees must ensure that they comply with the superannuation trust deed regarding, one, the notification requirements of potential trustee beneficiaries, two, affording all potential beneficiaries an opportunity to be considered under the trust deed, and three, giving real and genuine consideration to the beneficiary's claim of entitlement to any benefits to be paid out of the fund and to the surrounding circumstances before they make a decision. So therefore, it's essential that trustees then understand and interpret the trust deed correctly and clearly show that they have exercised a real and genuine consideration when making a determination as to how to make that distribution. And if they fail to do so, they may not only have the decision set aside, but in particular Rags cases, they may be removed as trustees also. Which now leads me, just you go on.
Yep, you go.
And which just leads me very shortly the lessons that have got to be learned from for superannuation members and trustees, as this case emphasises the risks then, for your client's wishes that may be overridden if the member does not have a valid death benefit nomination or similar document in place. And two, if the member does not wish to leave the distribution of death benefits to the discretion of the trustee or trustees, it is essential then that the member make a valid binding death benefit nomination or agreement which directs the trustee how to distribute funds to beneficiaries. So that's where it's sitting at the moment. And
so from that perspective, I don't think it's just. I know that was a self-managed super fund case, but it was actually a trust law case because they ended up removing the trustee on the fact that they didn't use their discretion wisely. Now, again, if you had a look at it, it was there was no binding death benefit nomination, so it was solely at the discretion, supposedly, as the trustee, and the trustee should have done their investigation. Now, obviously, given the fact that monies need to be paid out on death, and there had to be an investigation, it can actually probably roll over into a discretionary trust to a certain extent. For example, if we had a trustee of a discretionary trust, and there's a wide range of beneficiaries, and for example, we had a bloodline and non-bloodline, and that might be, for example, adopted child or secondary, child from second marriage, and the discretion was just exercised only for the bloodline children, there could be an argument there that provided those children from the second marriage were incorporated within the broad range of beneficiaries, they may potentially have an action under Marcellus, which is one of the reasons why it's really important that versus the discretionary trustee versus a leading member is to limit it to bloodline or lineage. At least gives us that opportunity of saying, well, this is the way it is. There is no discretion to go outside the bloodline or lineage, and therefore the only discretion is within that field of that field of operation versus going on a wider state of play. So I dare say at some point in time there will be an action under Marcellus against a discretionary trust and and definitely the use of discretion there. And that probably also go on. So that
just in relation to the what you were saying just now about discretionary trusts and that's why it's very important to actually get the trustee resolutions and the minutes correct from the start.
Absolutely, and by 30th of June too.
And you've also got to, exactly. And you've also got to look at the deed. At the deed very carefully to see what it can and can't do in terms of distribution of income and capital gains, and
more importantly, what income is.
Because I've seen deeds in the past. I've seen a deed in the past rather that they were making distributions, but yet the trustee didn't allow for that because there was no income distributions as part of that as part of the clauses in there. And they were distributing income for the last 5 years, which will have a significant impact should a tax audit occur now. That's the problem.
Yeah, I actually saw one just recently where it was a 1982 trustee, and it was death. It was a death duties trust, and they had no ability to distribute income at all. So it's a very, very scary one. From John, the death benefit split under Marcellus, what happened there though is they actually removed the trustee and then went back down for consideration as to what the split was. So that's probably the scariest one out of the whole process. Binding death benefit nominations around validity, you've just got to be very careful that it meets the relevant sections of the deed to make it valid. It's quite funny. I could probably do a whole hour on this, the Marcellus case versus Katz and Grossman, which is a similar sort of instance. They had the the dad died. They had a binding death benefit nomination where everything was supposed to go to the estate. And then it was to be split between the daughter and the son. And the daughter was a trustee of the superannuation fund or the SMSF. And then she had complete discretion and just paid it out to herself. And then the court held, she was entitled to do so and didn't really look into it. So Marcellus is the first time we've actually seen an imposition of a court. It's quite obviously Court of Appeals is quite heavy. I mean, you can't go any higher than that, can you, Tony? Not in
that's
not
right.
in Victoria.
Unless they take it to the High Court after, but it's not in the public interest at the end of the day, so it won't get up in any case. So they'll knock it back.
Yeah. So for that one, it's interesting though that they didn't go down an award. Well, this should have gone to this person. This should have gone to this person. What they did is they just removed her as trustee, kicked her out, and then obviously put in place a new trustee, which is the same thing that happens with the Commission of Taxation, that if you've got a recalcitrant trustee, he has the power and has done a number of instances to remove the trustee and appoint someone else as trustee. So it's a quite an interesting scenario there. And if you have a look at our SMSF will, we're very specific about how, one is it's got specific gifts, you can do a lot, but it's very tied into the deed, which it needs to be done. And of course, it's got witnesses. I know there's some lawyers around there saying you should be able to do a binding death benefit nomination without a witness, but that just seems a bit bizarre to me. So let's go on.
But just one last point, just in relation to the distribution, when you're making distributions at the end of the year for discretionary trusts,
which is next week.
Exactly. So it'd be good, you know, as part of that exercise to actually name in your distribution of minutes who you're going to distribute to in accordance with the deed. Not just say that we're going to distribute X amount of dollars. We don't know who it is, but you know
I
what
know
I mean?
exactly. No, there has to be specifics, otherwise it's out.
I'd like to see that, you know. So
yeah, well, you're fine with our minutes that you've helped draft. It's perfect for that. So if you have a look at the trust stuff, here we've added today a family protection trust in there. I am doing Tony and I are doing some deed of variations to discretionary trust for non-foreign purchases. We've had quite a bit of demand for that. I think that's the main thing for us is, look, if there's 2 or 3 people put their hand up and say we'd like to do this, then what we do is we bring that out. That upgrade from an existing discretionary trust to a leading member essentially can just put that through there. So that's the best way. The family protection trust. Now, this morning I actually did one here. I've got it in Abbott Test, and you'll see it was done this morning, which is a family protection trust. So I'll just go in. You can see here I can either download, delete, or I relaunch. So I'm going to relaunch and show you the fields, and then I'll show you what the ultimate product looks like before we get on to SMSF Death Benefits Trust. So if we have a look here, because it's gone into the vault, we want to have a name for the client, so we can then go and access it at any point in time. Use the Abbott Morley logo if you want. Otherwise, actually I was going to say Abbott Mornay, so like a tuna Mornay. Abbott Morley logo there if you want, or you might have your own logo as well. So the general is pretty easy. It's not much different from a lot of the leading member stuff. You'll see when I have a look at the documents, just a little bit of a twist there. So you've got the Smith Family Protection Trust. When's it going to be established? Whatever state it is. If we go to South Australia, then effectively the rule against perpetuities doesn't apply. So therefore we don't have a vesting. We put in there, we can put it in a charity if we want, or not applicable. We go to the set law. One of the ones there, I've got John Jr. Just be very careful if you're an advisor to the estate. There's quite a few lawyers out there who believe that's conflict of interest if you're the set law and also advisor to the estate. So there's a bit of a body of law there. You don't want to get involved on the wrong side of litigation on that one. So just get one of your junior staff to be the set law. Put that in, settle the amount. So far, so good. We've got a trustee company. Again, when we're using the trustee companies, I'll just go here. What we want to do is go to the company area. So we've got companies here. And we want to be using not the leading member SMSF special purpose. We want to use this leading member discretionary trustee company. Remember, that's the one where the shares are cancelled and new shares are issued to the next leading member appointer, which is going to become particularly relevant as we go down now. So we've got the company, we've set it up, and we've now put all the details into the system. So now we go down to the leading member appointors, which are essentially the family protection leading members, which we'll have a look at in a second. So we need to build that chain, that strong chain. So we've got the first in port is obviously John Smith. We've then got a second leading member, and we can have them joint if we want at that point in time. I've chosen no, and you can see each time we've got a choice. Do we want a second leading member? Do we want a third leading member? They can be joint or not. So what I've done is I've put the spouse as the second leading member. And now the third leading member, I've got Max Smith from his son. Now I've chosen not to go down further, but if I wanted to, I could easily just put in another one there. So I could go, for example, here. Oops, sorry, select. I could go yes, put down the fourth leading member, and then I'll go, is it a joint? I'll go no. And then we could put Jim Smith, who's his other son, who's at 100 Boomer Street, Melbourne, Victoria, 3,000. So we can do that. And again, so we've now got a really strong first, second, third, and our fourth leading member appointed, as you can see there. Now, the principal beneficiaries, so what we can do here is you can see when we get into the trust itself, we're going to actually see that it limits the beneficiaries to lineal descendants. of the leading member appointor. So what we want to do there is we've got to make a decision, is the spouse to be included or excluded? So I'll actually include the spouse here. Are any of the primary beneficiaries a company? I'll go yes, because we want to put a bucket company. Is any of them an incorporated association, such as a charity? So I put in the corporate beneficiary. I've got the old bucket company, put that in there. And then we go through the process. It doesn't take that long, and I finish it, and up will pop the PDF. So I'll just show you what that looks like, because I've put in another one. I've got another one that's a sample here, and I'll put the sample up on the when I release the notes for this. So we've just got here, we've got the PDF, and up it pops. It's got the Abbott Morley logo on, Family Protection Trust. The Family Protection Trust or leading member, either one's the same. The Family Protection Trust will become the default trust when we use it with a protector. So if you want to set up a protector, you'll see there's a button in the protector that enables you to choose to set up a trust. If you're going to do that, then it'll be a Family Protection Trust, which is the default one. So we go through the process and the stuff there. So again, we've got a D here, and the bit of the difference, you've got the settlor, we've got the trustee, but we've got now the leading member and family protector appointor compared to our leading member, which is just a leading member appointor. So what we've got here is the leading member has agreed to act as first leading member of family appointor. We go down a little bit further on, and you can see here's the chain. So the leading member and family, or the LMFPA, is John Smith of 5 Smith Street. In case of incapacity, resignation, or death, the next is Sally. In the case of Sally, then it goes to Max, so on and so forth. Now, in the event that there is no LMFPA, the trustee is off the roll to a beneficiary of the trust who is a bloodline descendant. So what we're doing there is we're making sure that everything is kept within that bloodline per se. Another one while we're here, we're going to look at this a lot more when we go down next week. Income of the trust means the amount as determined by the trustee. So that could be, for example, accounting income, or we could use our net income under section 95.1. So generally just got to be very careful about which one we want. The beneficiaries are obviously the LMFPA, the spouse. Now, if I hadn't ticked that, the spouse would be out. Any lineal descendant, child, grandchild, or great-grandchild of the LMFPA, to any other relative of the LMFPA born before the termination date, if any. So that would include future, say, grandchildren, so on and so forth. We've got the bucket company there, secondary trusts that are related to the LMFPA, superannuation fund, the trustee or trustees of any trust where the LMFPA is a member of the trustee, and obviously charitable as well. So we've got that down, and I won't go any further. You can delete beneficiaries, which is also important, again, from a family law perspective. So that's the Family Protection Trust. As I said before, that's going to be best used really with the protector. When we have a look at the last one, which is, in fact, we've got 2 more to go. The Testamentary Trust, I haven't got time to do that. We are building an accreditation platform of education whereby people will be able to be accredited as wills experts or wills and testamentary trust experts, so on and so forth. For those of you who have done our wills, and if you have a look at the LYD will, it's a really good, strong will that looks at that chain of executorship, much the same way we've got that chain of succession of appointors, which is very big in our thematic. The other one is that when we come around to doing bequests, the first thing that we do, or doing gifts, is we start off with specific gifts first, and then once all those gifts are done, everything else is paid out of the estate, all taxes, all loans, etc., settled. For example, if there's a protector, so there's a loan to the deceased, then at that point in time, the trustee of the protector will call in, which will actually be the next leading member, generally will call in that loan from the estate. And if we've done it well, there may not be anything in the estate anyway. So, but we sit down and we build that, so specific gifts, and then we then go into what's left over goes to the principal beneficiary. If they're not alive, it goes to secondary and tertiary and so on and so forth. And if there's no one alive, it ends up going to bloodline. So all of our stuff is really focused on that bloodline or the lineage. The other side of the coin is, from that perspective is that when you go from the LYD will to the LYD will with testamentary trust, at every option, whether it's a specific gift or whether it's the principal beneficiary of the residual estate, at every point in time, you can choose to put in place a testamentary trust. Now, inside there's a whole lot of buttons that you can fill, and I'll have to go back and do one again for you at some point in time. In fact, I'll come back. We're doing some sessions on it next Tuesday. But on those buttons, we can just tick the buttons and choose what the clauses and terms are for that testamentary trust. Now, bearing in mind, we don't produce the whole testamentary trust deed in there, because you could end up with 3 or 4 different testamentary trusts, and that would end up probably around about 200 pages, which would be too difficult for your client to understand. And there has been a number of cases where the fact that if the client didn't have the capacity, wasn't able to understand, that will has been held to be void. So we've just got to be very careful around that one, because it's an easy one. So we build it in generalities that then allows you as the advisor to come in and do more specifics on the death of the member. Children are accepted persons under the testamentary trust, so they're just taxed as adults. So those Division 6AA penalty provisions don't apply. The testamentary trust, it can be either, they can be multiple, but at any point in time we can choose them to be bloodline or lineage only, or not. We don't care about that. We have it open. The other one is, for each testamentary trust, you can either choose it to be mandatory, so it automatically applies. For example, if we've got a spendthrift child or someone who's in rehab or something like that, or you don't trust them, or it's just a child who's under 18, then we put in a mandatory testamentary trust. But if it's for an adult child, effectively, who's got a couple of kids, then we would potentially have the option there. So they could either take it, or they could put part in or part out. And that's again on the advice with you, or discussion with you as the advisor and also the executor. So there's a broad option there. Now, when we come around to the SMSF Death Benefits Trust, there's again, it's the same as a leading member trust that's built. Now, there's 2 ways of doing it. You can do it straight out of the testamentary trust rules. So you'll see there where you provide superannuation, and that's to go into a testamentary trust. That's a super proceeds trust, but we call it an SMSF Death Benefits Trust. So in that one, again, we've got the same thing. We've got our appointors, we've got our trustee, depends on who it's for. But likewise, the children, obviously that will be accepted persons and taxed as adults. Now, the only problem about that is going over to the estate would mean that it's potentially subject to a family provisions claim. Even if it's automatically transferred in there, anything can be basically challenged, even if it is, as I said, it's automatic. Whereas what we can do, there's a separate section of Section 102 AG, which allows us to transfer directly out. It's not that common, but it's for me it's preferred when we have a look at family provisions claims. So what we can do is the trustee of the superannuation fund can actually settle a trust for the benefit of a dependent. Now, it can only be a dependent of the trust, of the deceased. So that is, for example, any child, and it would also include anyone who's financially dependent. So we can actually create multiple SMSF Death Benefits Trust, or one that is for a multiplicity of dependents. It doesn't really make any difference. But again, it's a completely different beast than the testamentary trust. One of the main issues there is that on the vesting of the trust, at some point in time, you can transfer capital out, you can transfer income, much the same as any discretionary trust. However, what you must do is you must transfer any property. You saw earlier with the Family Protection Trust that you can transfer it out to a charity. Here, you must transfer it out to one of the original beneficiaries, or effectively their estate. Now, once you do that, you can't inject other income into that. But you'll see, I think I've got here down below. So you can see here, I've actually started to draft up the SMSF Death Benefits Trust. Looks as though, there we go. So this is our coded version. So I've started to draft that up, and that will be available. Probably what I'm going to look at is launching that at our conference coming up on the 14th and 15th of July. Now, just to finish off, if you haven't seen that, I'll send you out the link, but you can go onto Eventbrite and get that effectively. Now, as LYD users, or Light Year Docs users, you've got two choices. You can go into general admission, which is $248. If you're not an LYD user, then it's $199. But you go into the general admission ticket, and then you've got two codes. One, if you want 11 hours CPD, then you use the code LYCPD, and I'll put this out later. And the cost on that is $99 for the event. And it's a great event. It goes from 9 until 6 or 7. We've even got cocktails and everything. I know Tim and I are doing a session, Tony and I, we've got probably about 25 speakers, and it's a full-on, really great strategy day covering absolutely everything. If you don't want the CPD, then you just go LY no CPD, and that'll give you a free ticket. Next Tuesday, we now have our VIP strategy session, or it's what I call my, it's like just effectively, it's a strategy session every 11 a.m. I'll put that in to make sure that our Perth attendees can do it. It's our strategy roundtable. This week we looked at permanent capacity. Someone actually raised an issue, and we built a whole session around that. Also making self-employed contributions post-age 70. You'll find that they're all sitting in the Light Year Docs in those webinars. So that's put those up this morning. Next Tuesday, I'm doing 2 wills, which are going to be produced on the basis of some case studies that one of our advisors is sending in, and I'll be building those wills in front of you. So one will be ordinary will, and one will be a will with testamentary trust. So it's worthwhile, but we can only have 20 members because it's a very obviously interactive, where everyone has their say, obviously. If you need a ticket, go and have a chat with Sophia Abbott, who's my daughter, and it's sophia@ilovesmsf.com, and she can put you down for next week if you're really hankering to have a look at a will, which should be a really good session. Anyway, that's enough for me. Tony, thank you very much for giving us your input today. So, Kush, what's the difference between FPT and a discretionary trust? If you have a look at it, FPT is basically bloodline and security and certainty. Discretionary trust is more open than that. So if your client wants bloodline, lineage, protection, then you go the FPT, and that will be sitting in the family or in the protector when we go down and do that. Anyway, it's Grant Abbott and Tony and Willis signing off.
See you later.